Ladies and gentlemen, please come in. Professor Nikitin wants to lead us to the next session comfortably and pleasantly and effectively, as he always does. Please come in, and while you are being seated, the companions, which means wives or otherwise people who accompany you, not to restrict you in this particular aspect, right? Please advise them to be at the lobby of the hotel at 6 o'clock, and a bus will, no, not us, the companions. We are taken from here to the restaurant, and they will be taken from the hotel at 6 o'clock. By the time you will reach the hotel and you will make the speech, you will be hungry. Not them, not you. But you said you're not hungry, so I refer to you. So please advise your spouses, whether they are masculine or feminine. Tell them to be in the lobby. Or unclear, or undefined. Please ask them to be in the lobby at 6 o'clock for them to be picked up to the restaurant, which is called the 7 Fridays. What a name. I mean, expect to be looking at the one day and seeing many days, like Friday, right? And so now, Professor Nikitin, you are the leader.
Да, большое спасибо, господин Шетрит. Позвольте мне открыть нашу 4-ю и заключительную сегодня сессию. Она посвящена проблемам влияния транснациональной судебной практики на судейскую независимость. Мы все хорошо знаем принцип о том, что судья при отправлении правосудия независим и подчиняется только закону. Мы также хорошо понимаем, что речь идет в глобальном мире не только о национальном законе и о нормах международного права, о положениях, которые принимают те или иные наднациональные властные органы. Естественно, судья применяет все эти законы и нормы. Судья также ориентируется на судебную практику международных судов, наднациональных судов. И в этом смысле, мне кажется, очень интересно посмотреть влияние судебной практики этих международных и транснациональных судов на реализацию стандартов независимости судей. Наша сессия последняя как раз посвящена этим вопросам, и первым выступающим является уважаемый профессор Маккормак из университета Юта, который становится на проблемах применения международного уголовного права. Пожалуйста, профессор.
Спасибо. Добрый день. Don't worry, that's the last Russian you'll hear, except for one more phrase. I want to join my predecessors in saying спасибо большое to the organizers, the faculty, the staff, particularly at Art de Lex. Everybody has been wonderful, and the rest will be in English. In fact, I borrowed a phrase for those of you who are familiar. Oh, I should mention, if I have difficulty being understood, please let me know. I caught something respiratory on the trip, so let me know if I'm not understood. Those of you that are familiar with Martin Luther King Jr.'s speeches, I view this as my version of the I Have a Dream speech. I have a dream that someday we will actually enforce international criminal law and take it seriously. But before I get into that, I want to borrow a couple of ideas, steal some ideas, frankly. One from Dmitry Magonia this morning. I was quite glad that he raised the issue of poverty as a matter of human rights, and he pointed out that the U.S. now has a tremendous income inequality gap. He actually was, I think, too kind in his description, because our inequality gap is not only enormous but growing. And he was also too kind to the judiciary in saying that they could do anything about it. So I want to get to this idea of judicial independence through also borrowing an idea from Sophie, if I may, at least the title of your talk, accountability. Because to me, judicial independence is only achieved through following the law. Judges must be accountable, at least to themselves and to us, the academy and commentators, or they do not exercise independence. And according to Shimon, I managed to irritate a few people with a paper that I sent last year to San Diego, critiquing heavily the U.S. judiciary for losing much of its independence in the so-called war on terror by totally failing to hold the U.S. government accountable for many acts of wrongdoing. I will come back to that theme after I talk about international criminal law. So that's going to be the tie to this whole thing, and I will try to do enough to irritate everybody to keep you awake at this hour of the day. The categories of international criminal law in which I am most engaged at the moment have to do, of course, obviously with war crimes, or as it's now known, international humanitarian law. Pardon? Okay. Piracy, of course, has been in the news a lot and has now subsided to a large extent. I want to talk a little bit about terrorism, but not much. And primarily, I think the example I will use of where we are so sorely lacking in enforcement is the matter of slavery, a universally recognized crime for 200 years, which is virtually unenforceable, particularly in the category of sex slavery. And we all, I think, are aware of the dimensions of this problem. But it's not just sex slavery. It's domestic servants, it's agricultural laborers, it's a wide variety of people who are trafficked from one country to another. As soon as they arrive, their passports are taken. Any means they have of exercising independence, of negotiating power is gone. And the host country is virtually incapable of enforcement because they're benefiting, frankly, from the presence of all of these workers. And the countries that might be tempted to enforce, for example, if the U.S. decided to try to enforce the law against forced labor, against sex slavery in Asia somewhere, or the only thing we can do is punish the patron, the person, the U.S. citizen who comes back after engaging in prohibited illicit activity. There's virtually no way to reach much of this activity. And it's obvious in other areas as well. War crimes, we're all watching today, or this past couple of years, we've been watching the Syrian issue. We watched, frankly, just watched Rwanda, Bosnia, tried to some extent after the fact to impose sanctions as a matter of deterrence, but we know that it's really not effective. There is no truly effective sanction against international humanitarian law until you have some sort of military policing that is multinational in character. With those ideas in mind, the categories, as I said, of piracy, slavery, war crimes, and terrorism lead to the issue then of who will enforce, how can we enforce? Shimon mentioned earlier the distinction between international tribunals, of which we have a few, and supranational tribunals, of which we are desperately in need for some kind of enforcement power in these areas that I'm describing. But what happens if we get such a thing? What will happen is that necessarily the judges, in enforcing their own domestic law, will lose some autonomy to these supranational bodies, just as the courts of the UK were upset when they lost some autonomy to the European Court, and other national courts have expressed similar concerns. The overriding of international norms means that local norms must yield. We've been through this in the U.S. on many occasions. The European Parliament elections of this past week resulted in some rhetoric that is very familiar to those of us. It could have come straight out of the 1820s when the U.S. was just about to break apart into a very, very bloody civil war. But once every generation, we repeat this same rhetoric. Today we call it the Tea Party, this rhetorical flourish of the big bad government somewhere else is taking away our sovereignty, our autonomy. So I raise this as a matter of judicial independence because it means that when we get to the point of actually enforcing through supranational bodies in the international norms, I like that. Now do I have your attention? Can I just keep talking?
Our friend Irena explains that they are saying that you have to switch off the lights, to turn off the computers, to save energy before the end of the weekend. And so all the messages are not directed to Wayne. Nothing is against the United States. No war has broken out. It's total peace. We are a world of peace. Don't worry. And according to the sports practice, you take time out and you will get back your minutes. Here you are. Instead of the Bolshoi, we have an entertainment program.
Special for you. Special for you.
But there is no way to shut it, no?
I don't know. I'm not from here.
When I was responsible for television in Israel, it's quiet. There is a system of emergency invasion into the system that the government can do in emergency situation. So this is exactly it, that when you have to announce something for everyone, you take control over everything, including the lecture of Wayne.
Well, you realize in the U.S. now, government takes over everything that we say every time, every moment of every day. I felt that this was a special welcome
I know.
for the first American speaker.
I wanted to make sure that you don't feel too big too important that it is directed for you? Or addressed to you?
Okay. If anybody remembers where I was, let me know, okay? No, this is where I was going, so we'll skip to that. In all of these situations that I was describing in the U.S., what's happening in the EU, what is likely to happen if we ever do get to this point of a supranational enforcement, people will object to the intrusion on the sovereign prerogatives of their own domestic sphere. Of course they will. And that's, I don't want to downplay the importance of diversity. I mean, where would we be without Tchaikovsky and the Rolling Stones, right? We need all of that. Music, we need all of the art. We need various forms of dispute resolution. Tribal systems work well in many places. Informal dispute resolution is now actually a popular topic. In many places, we are actually teaching how to do it. And so I don't want to denigrate the idea that there need to be discrete, ethnically based or topographically, geographically based systems of law. What must happen, however, though, is with regard to certain universal norms, those judges will necessarily yield their autonomy, their sovereignty, if you want to call it that, to the universals. I was teaching a course, not teaching really, directing a programmatic, something like this kind of conference with prosecutors from Afghanistan at the time when there was an incident of a village elder, Yurga, deciding a dispute within the village between a farmer and a merchant. And that's a great way of doing things. The elders sit down under the tree, they decide what's best for the community, and that's all good because it's forward-looking. It's what's called restorative justice. And it's fine until the elders decide to give the 9-year-old daughter of the farmer to the 50-year-old merchant in town, and then when she runs away, she's jailed and prosecuted for disobeying the orders of her husband. There are certain universal norms that we simply have to accept. So judicial independence must yield to accountability. And that's where I then ran into problems with the U.S. system. I'll just list a few things. The emphasis that we've heard today on the culture of independence. It is a culture. It's not just the formality, the formal rules that count. When our judges in the U.S. show extreme deference and yield to the demands of the government on torture, on disappearance of persons, on extrajudicial detention, on targeted killing. I mentioned privacy earlier. There are no real international standards as yet on privacy, but judicial deference is really a counterpoise to judicial independence because it is not accountable. And so I want to raise this point that when we really get serious about international and universal norms, we're talking about yielding some of our autonomy to the universal community. I think I'll stop there and hope I've kept you awake for a moment. Thank you.
Большое спасибо, профессор Маккормак. Я думаю, даже обстоятельства чрезвычайной ситуации не помешали профессору сделать очень интересное выступление. Нашу сессию продолжает профессор Хадари из университета Тель-Авива. Выступление посвящено проблемам разрешения международных налоговых конфликтов. Так. Есть у нас профессор Хадари? Идет.
Hello, everybody. Let's enjoy the silence. No, I use my special connections with the band here. So now you're going to. All right. Goodbye. Hello, everybody.
Since Wayne mentioned the Rolling Stone, I think you've told me to a lot.
The Rolling Stone. Who was the one now that was in Israel? One of these guys. Yeah, he was in Israel. Okay. Okay. Maybe the Beatles will come also. Next visit, Shimon, will be the Beatles. Yeah, you forgot the Beatles, by the way. Okay. Shimon, I first of all have to compliment you for initiating this conference. It's a long time since we met, Shimon and me, as good friends for, don't believe it, but it's for over 40 years. When Shimon did his doctorate in law at the University of Chicago, studying the English system of courts and judges, and I did my doctorate degree at the University of Michigan, Ann Arbor, Michigan in the States. I dealt, though, with the multinational enterprises, but anyway, Shimon used to drive 4 or 5 hours from Chicago to visit us in Michigan. We never dreamed at that time, so we're going to meet in occasions like this here with this high standard of hospitalization. So I join and congratulate all the organizers, all those who participated. It's really beautiful. Now, how I can start? I can quote a quotation which relates to President Kennedy. I don't know if it's true or not, that when he came to the prison of Alcatraz, that's the most dangerous island of prison of the most dangerous prisoners, and he wanted to speak to them, and he didn't know how to open, how to turn them, so he started, "I'm glad you're all here." All right, I'll move the subject of the independence, complete independence of judges to another area and show it in totally another field. And that's my field, which is the field of taxation and international taxation. And I'll start to be very simple, so don't be afraid that I'm going to give you complex things in international tax law. But in international tax, now with the operation of the multinational enterprises, you have a lot of cases of double taxation, of cases of being taxed by several countries. At the same time, there is a problem of no taxation because of what is called legitimate tax planning. The multinational plan their way to pay tax to no country at all. It's high on the agenda in many developed states. But I'm going to relate a minute to conflicts. When two countries, it could be more, want to tax the same income of the operation of the multinational enterprise. Because the multinational enterprise is controlled by, let's say, parent company, which is located somewhere. We are Israeli, so let's take Teva. Teva is the biggest pharmaceutical company in the world in the generic production. And their headquarters is in Israel, but they have a lot of subsidiaries all over the world. Now, if Teva produce something in Israel, they do. They employ, I don't know, at least 5,000 or 10,000 people in Israel. If they produce something in Israel, and then they export it not to outside consumers, but to another branch or subsidiary of Teva somewhere in the world, let's say in the United States, and then the subsidiary in the United States add to it something in the States and resells it to the final buyer. Now, at the first stage, Teva has a price, because when they export it to Teva US, it has a price. We'll take a simple example. Let's assume that the price is 200. They quote it for 200. Now, it's unfinished good. It's a good which could be just research, could be just half a product. So they price it at 200. They say that according to Israeli tax authorities, they accept the price. This is the market price, the arm's length price, 200. So in Israel, it's fine. They pay the taxes in Israel, and Teva is happy. By the way, Teva pay almost no taxes in Israel because there is a special incentive for companies like Teva. So let's say that today the corporate tax is about maximum 10%, maximum. Go back a couple of years, it was 0. So if they paid, let's say, 10% in Israel, so they say the price is 200, so multiplied by the number of products, they get certain number, and all this number, they can deduct it in Israel for tax purposes. It's expense. That's no problem. But the problem starts when they reach the United States. Because the United States says, the tax authorities, Internal Revenue, IRS, they say, no. The price should have been 100, not 200. 100, which means that for when they resell it for 200 in the States, or over 200, 300, whatever, 400, all the rest is profit for the United States, which is taxable in the United States, and they give deduction only for 100 for Israel. And from United States perspective, most of the profit relates to the United States, subject to, let's say, 35%, which is the corporate tax in the States. Now, what should Teva do? Teva is now subject to, okay, this year, even to small tax, but subject to tax in Israel. And at the same time, is subject to tax in the States. But if you take the end price, part of it, large part is taxed twice. Because it's the part that Teva said that belonged to Israel. Americans did not accept it and said it belonged to the States. So there is here 100 here, the difference between 100 and 200, which is taxed twice, once by Israel, once by the United States. This is what we call double economic taxation. And so this is a big dispute. Now how are we going to settle it? In optimal world, there should be a treaty, multilateral treaty, that should divide the power to tax the multinationals among the countries. Each country would tax each multinational for the part of the income which is derived from that country, according to a formula. But there is no such treaty. There is no such agreement. All what we have worldwide are bilateral treaties, which means between Israel and the States, there could be bilateral treaty. And most bilateral treaties, what they say they have a common rule in there are hundreds of treaties, but almost in all of them follow the OECD model. In Article 9 of the model, they say that such intercompany transactions, we are controlled transactions, since the company can manipulate the price and shift the profit where the taxes are low, in our example to Israel, therefore, they say the price should be the arm's length price. It's the market price, arm's length. All right, so we come now to the hard question to decide, okay, the example of Teva, what is the arm's length price? We have to compare from what's going other prices, but this particular product is not manufactured anyway. You cannot compare it with anything. And then the only way the remedy for Teva is to go, which is called the mutual agreement procedure, or to go to the competent authority, to Israeli tax review, that they should negotiate with the American tax review, that they should try to settle this double taxation problem. And if they settle it, either they make a compromise. They said, okay, the price would be not 100 or 200, it would be 150, like King Solomon settlement. Or any other settlement, it's fine, they finished, there is no double taxation. But assuming that they cannot finish it, each competent authority would be stubborn and say, impossible. They say 100 and 200, so we still have 100 at issue. How we decided?